judges, Judge Tipsawit-Kun, Judge Sangkrai, and Judge Chitwaramong presiding.
Please be seated.
The case before the court is the case concerning the Corona Labu people. The parties are the applicant, the Kingdom of Amaranth versus respondent, the state of Georgia. The applicant and the respondent are each allocated 35 minutes to present their pleadings.
So if the counsel for the applicant is ready, please.
Please feel free to adjust the mic. Good morning, Your Excellencies. My name is Satin Gupta, appearing on behalf of the applicant, the Kingdom of Amaranth. My co-counsel, Ms. Arisara Kuntuam, I will be addressing Claim 1 for 16 minutes, along with my co-counsel, Ms. Arisara Kuntuam, who will be addressing Claim 2 for 16 minutes. We respectfully reserve 3 minutes for rebuttal. Your Excellencies, I made 3 submissions. 1. Rotia violated Article 7 of the Treaty of Oslo. 2. Rotia cannot rely on self-defense as a justification for the damages as a result of Operation Battle Sword. And 3. Rotia violated the necessity and proportionality rule. May it please the court. Proceeding to the first argument, counsel argues that Operation Battle Sword violated all 3 subparagraphs of Article 7.
Sorry, before we proceed, it seems that you are basing your argument on the Treaty of Oslo, which is a tripartite treaty. So that means that our interpretation, our judgment on this matter is going to affect or concern the third state. Can we and should we proceed this proceeding without the involvement of the third state that is a party in that treaty?
Your Excellency, in this case, the dispute concerns Amaranth as well as Rotia, and both of whom are parties to the state. Concerning, in response to Your Excellency's concern about a third state, because there is only 2 parties in relation to this dispute, counsel believes that it is valid that the only 2 parties here today are Amaranth and Rotia. Proceeding with counsel's argument, Operation Battle Sword violated all 3 subparagraphs of Article 7. The interpretive framework for treaties is set out in Article 31 of the Vienna Convention on the Law of Treaties. Provisions must be interpreted in good faith, according to their ordinary meaning, in context, and in light of their object and purposes. Article 7.1 of the Treaty of Oslo prohibits military operation and military weapons in the Malakal Tract. The only exception being is where in the moment of the attack, in the moment of launching a strike from Rotia, if Rotia's administrative control or peace and order in the tract is under threat, which the respondent could argue includes the use of force.
The language of Article 7, Paragraph 1 seems broader than you have just suggested now. So is it any conduct by Russia to maintain the administration and order? So how did you reach that sort of restrictive reading?
Can Your Excellency emphasize on the question?
The exception to Article 7 is in the second paragraph, second sentence of paragraph 1 of Article 7. And the language seems broader than what you said, because it said the only permitted exceptions shall be any conduct by Rotia to maintain its administration and order in the tract.
Your Excellency, Council believes that pursuant to looking under the BCLT, which allows the court to look at the preamble and the objective, Council believes that the interpretation of the Treaty of Oslo, when interpreting, it does require stricter interpretation, which is what Council has argued. Continuing with Council's argument, in the moment, reading with the preamble, this power was intended to entrust Rotia with preserving peace in the Malakal Tract, particularly to prevent the atrocities seen during the Malakal War. At the time of attack, there was no threat to Rotia's administrative control in the Malakal War, nor any disruptions that would warrant such force. Respondents may rely on prior FBM incidents, although those were already being addressed through law enforcement rather than military means. Furthermore, the gap between Operation Serena and Operation Balsor suggests that there was a less alternative means that, according to the preamble of the Treaty of Oslo, Rotia should have taken to prevent civilian casualties. Annex 2 of the fact shows that the impact of the strike extended beyond the tract and into Amaranth territory, destroying sections of the expressway. Damage of the scale and range is consistent only with the use of state military assets. Further, Rotia itself referred to the strike as Operation Balsor. From this, we can infer that the operation was planned and organized on a state level. Finally, the strike was conducted beyond Rotia's territory, demonstrating a capability consistent with the deployment by the Rotian armed forces. Taken together, this shows that there was no urgent reason to resort to military force, and therefore the exception to demilitarization does not apply. While no single piece of evidence is decisive on its own, together it can be inferred that